Okay, so they teach us this stuff in real estate school, but as soon as you graduate, you promptly forget it because you're not allowed to talk about it because it's very legal. And it's how do you buy a house when you are buying it, investing with somebody else, or you have two people coming together to buy a house. So joint tenants in common and tenants with, I don't even know. Josh is going to go over it with us because it's super confusing. I'm Maureen Mahood and we're here with Josh Grabowski. Today we're going to talk about tenants in common and all the tenancies. Josh is with Grabowski Law. Josh, like I said, we learned this in real estate school, but then they tell us you can't talk about it because it's all legal things. Like I can never tell somebody how to take a deed. So why is this super important?
You want to make sure that you're choosing the correct option that works for you and the relationship that you have with the other person or persons that you're buying real estate with. I guess the first one I want to knock out is tenants in common, because this is the default. This is, if you make no option, this is what you'll have. And this is, unless you're married. But let's assume you're buying property with someone you're not married to, like an investor, a sibling, or it's a parent and a child, or two friends going out on a flip project, whatever the case may be, two people not married to each other. The default is tenants in common. And let's say you have two people, person A passes away, person B survives. Person A's interest, their half interest, will go to their heirs. So now person B still owns half the property, but they share it with whoever the heirs of their co-investor was. So that can get messy, especially if this person doesn't have a will. What if they have a dozen heirs? Now person B is stuck with this person's 12 or so, however many heirs. But this is typically the model preferred by investors because they want to protect their interest and that it goes to their estate. If you don't want that to happen, that is when you put in the language joint tenants with rights of survivorship. Now, what this means is same example, person A, person B, person A dies, person B now owns the house outright. There's no heirs coming in that situation whatsoever. That's typically the situation preferred by relative investors, the parent and child, maybe the brothers.
Yeah.
But it's ultimately up to them.
It's important when you're trying to do anything financially with somebody that you have the exit plan, and the exit plan could be the death. So if you do have the tenants, the joint tenancy, and you don't do the right of survivorship, can you still direct how that works? You would want a will or that. So the state's not saying, okay, if I have a friend that we're going to do a flip together and they've got 5 kids and I don't really want to be in business with those 5 kids, right?
Yeah.
But maybe there's one of them or something like that.
That would still be the first option, tenants in common. And then maybe that person has an estate plan that's agreeable to you. You would want to go with rights of survivorship, joint tenancy, so that your investment stays with you instead of passing off to their heirs. There is a key distinction based on what we talked about with probate, is tenants by the entirety. This is going to be the automatic option for married couples.
Okay.
You're married and you're on a deed, or if you were unmarried when you bought it and then you get married afterwards, you have tenants by the entireties. No probate is required to clear title. If your spouse dies and you're married at the time, you now own the house outright and can sell it without the need of probate. As soon as the person dies, their heirs own it. Even though there's no recorded deed, they technically own it by operation of law the second that person dies. And the reason for that is because real estate can't be owned by no one.
Oh, that's interesting. So real estate can't be owned by no one. If your parent dies and you're the only child, then it automatically goes in your name.
Well,
without even have to do.
You automatically own it.
You automatically own it.
Yeah. Once you, again, going back to our probate conversation, this is why you have to probate to clear the title, had the executor sign out a deed, and now you have a nice, clean and looking title to transfer to somebody else. But you technically own it before all that.
If we're buying a house together, the deed, how that deed is written is important in case something happens to one of us.
Correct. And it's important to know what those differences are so you can choose which one makes sense for you.
Yeah, and you probably want to discuss it before actually purchase the house. What happens if one of us dies? Am I going to be with your kids? Because we talked about the partition thing. So if let's say your boyfriend, girlfriend buying a house together and one of you dies, then that is going to go to their heirs and they could force you to sell that house.
Yeah, theoretically that could happen. Sure. You would still be out your half interest, but yeah, they could, whatever your intention for the property was, if it was to hold it long term, they could come in and force you to sell the property.
Force you to sell it. So all these videos come together.
Yeah. Yeah.
It's a complicated process. Okay. So go through it one more time. Tell us what the choices are.
Sure. So tenants in common, remember this is the default. So if you guys don't make a selection, this is the one you're going to end up with. This is the one where if someone on title passes away, their share of their interest goes to their heirs. Joint tenants with rights to survivorship gives it away. This is the one where you have to add that language specifically. And if someone passes away, their interest just transfers to the other owner. And then tenants by the entireties, this is just for married couples and it's the automatic scenario for them. Same as with rights to survivorship, but no probate required.
And you ask your attorney when you're buying property, no matter what, to write the deed whichever way you want.
Correct. Yeah. And if we don't put anything, it's going to be tenants in common. But ultimately, it's important to have these conversations just to make sure that you're aware of the ramifications of each scenario. Discuss it with your partner or whoever you're investing or buying with, and that you're satisfied with the potential outcomes in the scenario that one of them passes away.
And by default, do attorneys actually ask people, how do you want to take this deed?
Anytime I have unmarried buyers buying property together, I always ask them which of those two options they want. I would suggest to all attorneys that they ask, you should ask.
And as a real estate agent, if I'm working with somebody like that, I should say, hey, since you're doing this, you need to talk to the attorney about how you're going to take title.
Absolutely. Yeah. If you have buyers, that are in, if you have buyers that fall into the category of 2 or more, not married, you should make sure that they get in touch with the attorney so they can discuss that.
So complicated.
It's easy when you boil it down.
Super complicated, but if you don't know.
I think it's all the antiquated terminologies they use in the terms of art. They make it sound very complicated, but it's pretty simple once you boil it down.
Okay, I'm Maureen Mahood, broker owner of Sell Your Home Charlotte here in beautiful Charlotte, North Carolina. I help people buy and sell real estate in the Charlotte Metro. So if you need help with that, I'm your girl. Josh, go ahead and tell them what you do.
Yep, my name is Josh Lipbach. I'm an attorney with Grabowski Law, and I'm a real estate attorney here in South Park in Charlotte.